Capital punishment is a legal penalty in the United States, currently used by 32 states and the federal government. Its existence can be traced to the beginning of the American colonies. There were no executions in the entire country between 1967 and 1977. In 1972, the U.S. Supreme Court struck down capital punishment statutes in Furman v. Georgia, reducing all death sentences pending at the time to life imprisonment. Subsequently, a majority of states passed new death penalty statutes, and the court affirmed the legality of capital punishment in the 1976 case Gregg v. Georgia. Since then, more than 1,400 offenders have been executed, including 28 in 2015. The United States is the only Western country currently applying the death penalty and was the first to develop lethal injection as method of execution, which has since been adopted by 5 other countries. History. Pre-Furman history. The first recorded death sentence in the British North American colonies was carried out in 1608 on Captain George Kendall, who was executed by firing squad at the Jamestown colony for allegedly spying for the Spanish government. The spy file, compiled by M. Waterspy and John Ortiz Smycler, lists 15,269 people executed in the United States and its predecessor colonies between 1608 and 1991. From 1930 to 2002, there were 4,661 executions in the U.S., about 2/3 of them in the first 20 years. Additionally, the United States Army executed 135 soldiers between 1916 and 1955. The Bill of Rights in 1789 included the Eighth Amendment, which prohibited cruel and unusual punishment. The Fifth Amendment was drafted with language implying a possible use of the death penalty, requiring a grand jury indictment for capital crime, and a due process of law for deprivation of life by the government. The 14th Amendment, adopted in 1868, also requires a due process of law for deprivation of life by any state. 3 states abolished the death penalty during the 19th century: Michigan in 1846, Wisconsin 1853, and Maine 1887. Rhode Island is also a state with a long abolitionist background, having repealed the death penalty in 1852, though it was theoretically available for murder committed by a prisoner between 1872 and 1984. Other states which abolished the death penalty for murder before Gregg v. Georgia include Minnesota in 1911, Vermont in 1964, Iowa and West Virginia in 1965, and North Dakota in 1973. Hawaii abolished the death penalty in 1948 and Alaska in 1957, both before their statehood. Puerto Rico repealed it in 1929 and the District of Columbia in 1981. Arizona and Oregon abolished the death penalty by popular vote in 1916 and 1964 respectively, but both reinstated it, again by popular vote, some years later, Arizona in 1918 and Oregon in 1978. Puerto Rico and Michigan are the 2 only U.S. jurisdictions to have explicitly prohibited capital punishment in their constitutions, in 1952 and 1964, respectively. Nevertheless, capital punishment continued to be used by a majority of states and the federal government for various crimes, especially murder and rape, from the creation of the United States up to the beginning of the 1960s. Until then, save for a few mavericks, no one gave any credence to the possibility of ending the death penalty by judicial interpretation of constitutional law, according to abolitionist Hugo Bador. The possibility of challenging the constitutionality of the death penalty became progressively more realistic after the Supreme Court of the United States decided Trop v. Dulles in 1958, when the court said explicitly for the first time that the Eighth Amendment's cruel and unusual clause must draw its meaning from the evolving standards of decency that mark the progress of a maturing society rather than from its original meaning. But in the 1932 case Powell v. Alabama, the court had already made the first step of what would be later called the "death is different" jurisprudence, when it held that any indigent defendant was entitled to a court-appointed attorney in capital cases, a right that was only later extended to non-capital defendants in 1963, with Gideon v. Wainwright. Capital punishment struck down in Furman v. Georgia. The U.S. Supreme Court considered a group of consolidated cases. The lead case involved an individual convicted under Georgia's death penalty statute, which featured a unitary trial procedure in which the jury was asked to return a verdict of guilt or innocence and, simultaneously, determine whether the defendant would be punished by death or life imprisonment. The last pre-Furman execution was that of Louis Monge on June 2, 1967. In a 5-4 decision, the Supreme Court struck down the impositions of the death penalty in each of the consolidated cases as unconstitutional in violation of the 8th and 14th Amendments of the United States Constitution. The Supreme Court has never ruled the death penalty to be per se unconstitutional. The 5 justices in the majority did not produce a common opinion or rationale for their decision, however, and agreed only on a short statement announcing the result. The narrowest opinions, those of Byron White and Potter Stewart, expressed generalized concerns about the inconsistent application of the death penalty across a variety of cases but did not exclude the possibility of a constitutional death penalty law. Stewart and William O. Douglas worried explicitly about racial discrimination in enforcement of the death penalty. Thurgood Marshall and William J. Brennan, Jr., expressed the opinion that the death penalty was prescribed absolutely by the Eighth Amendment as cruel and unusual punishment. The Furman decision caused all death sentences pending at the time to be reduced to life imprisonment, and was described by scholars as a legal bombshell. The next day, columnist Barry Schweid wrote that it was unlikely that the death penalty could exist anymore in the United States, but instead of abandoning capital punishment, 37 states enacted new death penalty statutes that attempted to address the concerns of White and Stewart. Some states responded by enacting mandatory death penalty statutes which prescribed a sentence of death for anyone convicted of certain forms of murder. White had hinted that such a scheme would meet his constitutional concerns in his Furman opinion. Other states adopted bifurcated trial and sentencing procedures, with various procedural limitations on the jury's ability to pronounce a death sentence designed to limit juror discretion. The court clarified Furman in Woodson v. North Carolina and Roberts v. Louisiana, which explicitly forbade any state from punishing a specific form of murder with a mandatory death penalty. Since Furman, 9 states have organized popular votes dealing with the death penalty through the initiative and referendum process. All resulted in a vote for reinstating it, rejecting its abolition, expanding its application field, specifying in the state constitution that it is not unconstitutional, or expediting the appeal process in capital cases. Capital punishment resumption in 1976. Contemporaneously with Woodson and Roberts, the court decided Gregg v. Georgia and upheld 7-2, a procedure in which the trial of capital crimes was bifurcated into guilt, innocence and sentencing phases. At the first proceeding, the jury decides the defendant's guilt. If the defendant is innocent or otherwise not convicted of first-degree murder, the death penalty will not be imposed. At the second hearing, the jury determines whether certain statutory aggravating factors exist, whether any mitigating factors exist, and, in many jurisdictions, weigh the aggravating and mitigating factors in assessing the ultimate penalty, either death or life in prison, either with or without parole. In 1977, the Supreme Court's Coker v. Georgia decision barred the death penalty for rape of an adult woman. Previously, the death penalty for rape of an adult had been gradually phased out in the United States, and at the time of the decision, Georgia and the U.S. federal government were the only two jurisdictions to still retain the death penalty for that offense. Executions resumed on January 17, 1977, when Gary Gilmore went before a firing squad in Utah, but the pace was quite slow due to the use of litigation tactics which involved filing repeated writs of habeas corpus, which succeeded for many in delaying their actual execution for many years. Although hundreds of individuals were sentenced to death in the United States during the 1970s and early 1980s, only 10 people besides Gilmore were actually executed prior to 1984. Subsequent history executions raised at near continuous pace until 1999, when it picked up at 98. After 1999, executions near continuously lowered every year, and the 28 executions in 2015 were the fewest since 1991. The death penalty was a notable issue during the 1988 presidential election. It came up in the October 13, 1988 debate between the two presidential nominees George H.W. Bush and Michael Dukakis when Bernard Shaw, the moderator of the debate, asked Dukakis, "Governor, if Kitty Dukakis were raped and murdered, would you favor an irrevocable death penalty for the killer?" Dukakis replied, "No, I don't, and I think you know that I've opposed the death penalty during all of my life. I don't see any evidence that it's a deterrent, and I think there are better and more effective ways to deal with violent crime." Bush was elected, and many, including Dukakis himself, cite the statement as the beginning of the end of his campaign. Negative ads were also aired portraying Dukakis as soft on crime, citing explicitly his opposition to the death penalty. In 1996, Congress passed the Anti-Terrorism and Effective Death Penalty Act to streamline the appeal process in capital cases. The bill was signed into law by President Bill Clinton, who had endorsed capital punishment during his 1992 presidential campaign. The U.S. Supreme Court has placed two major restrictions on the use of the death penalty. First, the case of Atkins v. Virginia, decided on June 20, 2002, held that the execution of mentally retarded inmates is unconstitutional. Second, in 2005, the court's decision in Roper v. Simmons struck down executions for offenders under the age of 18 at the time of the crime. In the 2008 case Kennedy v. Louisiana, the court also held 5-4 the death penalty unconstitutional when applied to non-homicidal crimes against the person, including child rape. In 2004, New York and Kansas capital sentencing schemes were struck down by their respective state highest courts. Kansas successfully appealed the Kansas Supreme Court decision to the United States Supreme Court, who reinstated the statute in Kansas v. Marsh, holding it did not violate the U.S. Constitution. The decision of New York Court of Appeals was instead based on the state constitution, making unavailable any appeal, and the state lower house have since blocked all attempts to reinstate the death penalty by adopting a valid sentencing scheme. In 2007, New Jersey became the first state to repeal the death penalty by legislative vote since Gregg v. Georgia. Nebraska, followed by New Mexico in 2009, Illinois in 2011, Connecticut in 2012, and Maryland in 2013. The repeals were not retroactive, but in New Jersey, Illinois and Maryland, governors commuted all death sentences after enacting the new law. In Connecticut, the state top court ruled in 2015 that the repeal must be retroactive, making New Mexico the only state with remaining death row inmates though no present death penalty statute. Nebraska's legislature also passed a repeal in 2015, but a referendum campaign gathered enough signatures to suspend it, meaning that the death penalty remains legal in the state, until the electorate will decide to retain or repeal the bill on November 8, 2016. In June 2015, the U.S. Supreme Court reaffirmed the constitutionality of lethal injection in Glossop v. Gross. Justice Breyer, joined by Justice Ginsburg, wrote a dissenting opinion saying it was time for the court to prohibit capital punishment entirely, believing it is highly likely that the death penalty violates the Eighth Amendment, because of unreliability, arbitrariness, and unconscionably long delays that undermine the death penalty's penological purpose. Because Breyer and Ginsburg are not the first justices to change their minds on that issue, the move led to a scathing retort from Justice Scalia, joined by Justice Thomas, who began his concurring opinion by saying, "Welcome to Groundhog Day." He expressed the view that whenever a justice asserts it is now time to judicially abolish the death penalty, he only advances the same contentions who have not convinced the court earlier. Justice Thomas, joined by Justice Scalia, also wrote a concurring opinion in this case, saying that Breyer and Ginsburg are engaging in the ceaseless quest to end the death penalty through undemocratic means, and that the court should never have prohibited mandatory death sentences, because they are the best way to impose a uniform death penalty appliance. He felt contradictory that some judges were willing to get rid of the death penalty on the grounds of a sentencing arbitrariness and delays for which the court itself is to blame. States and territories without capital punishment. Abolition before statehood. Several states have never had capital punishment, the first being Michigan, which abolished it shortly after entering the Union. Article 4, Section 46 of Michigan's Fourth Constitution prohibits any law providing for the penalty of death. Attempts to change the provision have failed. In 2004, a constitutional amendment proposed to allow capital punishment in some circumstances failed to make it on the November ballot after a resolution failed in the legislature and a public initiative failed to gather enough signatures. The two newest states, Alaska and Hawaii, abolished the death penalty prior to statehood, though Alaska executed 8 men when it was a territory. Other early repeals. Other states with long histories of no death penalty include Wisconsin, Rhode Island, Maine, North Dakota, Minnesota, West Virginia, Iowa, and Vermont. The District of Columbia has also abolished the death penalty. It was last used in 1957. Oregon abolished the death penalty through an overwhelming majority in a 1964 public referendum but reinstated it in a 1984 joint death penalty, life imprisonment referendum by an even higher margin after a similar 1978 referendum succeeded but was not implemented due to judicial rulings. Abolition. The District of Columbia and the following 18 states currently do not have an enforceable death penalty statute. Notes: Vermont retains capital punishment for treason. In these states, the death penalty statute was struck down by court ruling. In these states, the death penalty is enforceable for offenses committed before the repeal, that is, abolition was not retroactive. In 2007, New Jersey became the first state to repeal the death penalty during the modern era of capital punishment, followed by New York in the same year, New Mexico in 2009, Illinois in in 2011, Connecticut in 2012, Maryland in 2013, and Nebraska in 2015. It could be reinstated in Nebraska by a vote in November 2016. In New Jersey and Illinois, all death row inmates had their sentences commuted to life in prison without parole when the death penalty repeal bills were signed into law. In Maryland, Governor Martin O'Malley commuted the state's 4 remaining death sentences to life in prison without parole in January 2015. While the bill repealing capital punishment in Connecticut was not retroactive, the Connecticut Supreme Court ruled in 2015 in State v. Santiago that the legislature's decision to prospectively abolish capital punishment rendered it an offense to evolving standards of decency, thus commuting the sentences of the 11 men remaining on death row to life in prison without parole. New Mexico may yet execute 2 condemned inmates sentenced prior to abolition, and Nebraska has 10 death row inmates who may still be executed despite abolition. 4 states in the modern era: Nebraska in 2008, New York and Kansas in 2004, and Massachusetts in 1984, had their statutes ruled unconstitutional by state courts. The death rows of New York and Massachusetts were disestablished, and attempts to restore the death penalty were unsuccessful. Kansas successfully appealed State v. Clepass, the Kansas Supreme Court decision that declared the state's death penalty statute unconstitutional, to the United States Supreme Court. Nebraska's death penalty statute was rendered ineffective on February 8, 2008 when the required method, electrocution, was ruled unconstitutional by the Nebraska Supreme Court. In 2009, Nebraska enacted a bill that changed its method of execution to lethal injection. Puerto Rico. The United States territory of Puerto Rico has no death penalty. Puerto Rico instituted a 4-year moratorium on the death penalty in 1917. The last execution took place in 1927, and the Puerto Rican legislature abolished the death penalty in 1929. Puerto Rico's constitution expressly forbids capital punishment, stating, "The death penalty shall not exist," setting it apart from all U.S. states and territories other than Michigan, which also has a constitutional prohibition. However, capital punishment is still applicable to offenses committed in Puerto Rico, if they fall under the jurisdiction of the federal government. Though federal death penalty prosecutions there have generated significant controversy.